Okay, so good afternoon, or is it good evening? It's late in the afternoon. Today is the 10th of February, 2021. It is my pleasure to introduce our guest speaker for today in our knowledge sharing session for the Green Enterprise Initiative, facilitated by Simuka Human Capital. Moreblessing Mare is a human resource management expert. But without further ado, I'm going to give Moreblessing the floor to introduce himself.
Thank you so much, Mr. Mzambo, for the introduction, for the welcome remarks. My name is Moreblessing Mare. I'm a human resource practitioner. Maybe I can give a brief background of myself. Moreblessing Mare is a managing director or managing consultant of Payroll Professional Resource Center, a consulting organization focused mainly in HR management, compensation benefits management, job evaluations. Payroll Professional Resource Center, it's based also in Zimbabwe, but we are also registered in South Africa, where we do also other operations, mainly focusing from the Southern African region. We do trainings in regards to payroll management. We do trainings in terms of job evaluation, compensation and benefits management, and also we are focusing in terms of also other human resources policies for organizations within also the Southern African region. Currently, we are also working in terms of trainings for 2021, covering most of the Southern African region. Many countries in the Southern region. Previously, we have done trainings in Botswana, we have done trainings in Zambia, also in South Africa with regard to compensation and benefits management. That's many of our clientele are, and also in Zimbabwe, we also do consultation in terms of compensation and benefits management. And also, we also run a payroll bureau services, whereby we also give our clients payroll services in terms of processing, and also doing payments, compliance management issues with regards to payroll issues. We also focus in terms of helping many organizations in terms of doing their policies, assisting them in terms of labor advisory issues, in terms of managing their contracts of employment, in any other HR matters. That's our main focus is Payroll Professional Resource Center for in Zimbabwe, also in South Africa. Like I've shared earlier on, we also focus in the Southern African region. Now we are also focused in terms of online trainings across, whereby people, they can do payments wherever they are. If you're in Zambia, you can do our online payment using our portal. You can do it once the payment is filled in our bank account, then we can start doing the trainings for you. And also, we are also registering, focus in terms of registering an academy for payroll management, for which will cover also the Southern African region. That's Moreblessing Mare, a world of Master of Business Management, and also various degrees and diplomas in human resource management. And also, in addition to that, also I'm also a trainer, a facilitator for IPMZ for the module in terms of compensation management, module developer, and also facilitate for the Institute of Personal Management of Zimbabwe at the moment. Thank you so much. I think that's a brief view of Moreblessing Mare.
Thank you very much, Mr. Mare. I don't know if you're comfortable with Moreblessing or Mr. Mare. What are you?
Moreblessing is okay, no problem with that.
Okay, thank you for that. Maybe I also didn't give our audience my name. My name is Ruben Mambo. I'm the one who's hosting the HR and knowledge sharing session. Maybe Mr. Mare or Moreblessing, as you have said you prefer to be referred to as. Moreblessing, you told us so much about what you offer in your organization and your role in the organization. But maybe just give us a brief background of how you came to be. What's your past like? Where have you started off from? Did you just start off as a consultant? Did you work somewhere? did you start off as a managing director? How did you, what's been your path like? Can you just briefly in 3 to 5 minutes just share with us that aspect?
Thank you so much, Ruben, for that. I think I might have skipped that in terms of the background. My background is Moreblessing. I have over 20 years experience in the industry. I started working in the retail sector at various positions, and also I once worked in the tourism sector. I've been in the manufacturing sector, in the HR department, and also been also in the non-governmental organization, also in the human resource aspect. Prior to during that period, also I've assisted various organizations whereby we used to do the capacitation of various our partners in terms of their HR systems. Also, I've done also assistance like one organization, Blawayo, which MMMPZ, during my period of employment. That's my career as an employee span for a period of close to 20 years. But prior to that also, I think during my around the 15th year, I was also started doing part consultants in terms of facilitation trainings, and also part-time consultants prior to that. In brief, I think that's the background. Mainly my area of expertise, I've during my period of employment was in terms of human resource strategy management, compensation and benefits management, including pensions management, and also in terms of labor relations, where also I've been working for various organizations like Keynes Foods Limited, Thomas Miko Stores, Catholic Relief Services, Schweppes Zimbabwe. I've also worked for Rainbow Tourism Group. Those are some of the organizations I worked for during my 20 years of employment.
Thank you very much. I think we will be revisiting your career path and your what you currently offer as we go through the material whenever necessity arises. So let's immediately move on to the business of the day. I would want to give you the floor so that you can take us through the presentation, and then I'll obviously be asking questions for clarification as we proceed.
Okay, thank you so much, Ruben, for that. Maybe to just give a highlights of HR management, because mainly we focusing in terms of the SMEs. HR management is quite diverse. It covers issues to do with recruitment, selection. It covers things to do with industrial relations. It covers also to do with compensation and benefits management. It also covers in terms of training and development. But mainly when you are focusing in terms of HR management, there are regulations which govern the human resource practice in our environment for Zimbabwe. Mainly we work for the prime legislation which deals with human rights management. We have got the Constitution of Zimbabwe, section 65, which also covers in terms of the labor relations issues which affect organizations or employees within the employment sector. That's the Constitution of Zimbabwe. We also have the Labor Act, the Chapter 28.01 in Zimbabwe, which also the principal act which deals with employment relations in an organization or in the industry. And also under that, we also will focus on in terms of the issue of what is casualization at the workplace, and what are the implications of casualization. Many organizations, they employ employees on fixed-term contract, as casual laborers, as short-term contracts, some on permanent basis. But we want to explore what is the ramifications of casualization at the workplace, whereby many organizations, they practice it unknowingly, they will be committing an offense. We also deal with issue of discrimination at the workplace. When we focus on discrimination, mainly our prime source is the Constitution of Zimbabwe, also in line with the Labor Relations Act, the Labor Act in 2001, and also we focus in terms of issue of what constitute harassment at the workplace, and also issue of job descriptions. When we talk about job description, we also focus in terms of the job analysis. What are the impacts of the job description at the workplace, and also some, when they're advertising their recruitment, they have to come up with what we call job specification. What are the impacts of the job specification and what is contained in it, and what are the best practice for organizations, especially SMEs, what they can do in terms of to assist them in terms of managing their employment relations at the workplace. We will also focus in terms of the compensation. Mainly, we are focusing in terms of what is the requirement in terms of our legislation in Zimbabwe in terms of compensation and benefits, and also what are the prime source in terms of which guide in terms of remuneration or compensation at the workplace in Zimbabwe. Basing from there, then also we'll focus in terms of the issue to do with grievances, discipline, and termination of employment at the workplace. Those are the key issues we are going to focus on today as we discuss issues which also affect employers and employees at the workplace. Maybe to just give a highlight to start with, generally our constitution in Zimbabwe, the Zimbabwean constitution, which is the principal law or the supreme law of the country, it gives us a guide in terms of what is the issues which are supposed to be practiced at the organization, mainly with regard to rights of an employee, because an employee has got various rights which they enjoy at the workplace. But the prime, under section 65 of the Constitution of Zimbabwe, it gives guide that the employees, the right of every employee at the workplace, they've got a right to a just treatment, the right to a fair treatment at the workplace, and they also have to a right to an equitable or fair in terms of their remuneration. So in terms of the question of the section 65 of the Constitution of Zimbabwe, it just gives a brief guideline in terms of what the employees' rights are in terms of the work environment. So those rights, if we now go to the Labor Act, those rights are now they are now explored further to say, when you are talking of the just workplace, what are we focusing? When we are talking of in terms of compensation, what are we focusing? When we are focusing in terms of the benefits which are entitled to an employee at the workplace, what are we focused on? And when we are talking in terms of the rights of an employee in terms of a democratic workplace, the right to join a union, the right to be a member of any union, the right to association in terms of membership. What are we focusing on, and what are the pitfalls many organizations or SMEs do in terms of infringing those rights which are enshrined to every employee in regard to the our constitution, and also with regard to the Labor Relations Act. That's why in most cases, when in an employment sector, when there's a dispute of right, an employee can even appeal further to the Supreme Court, and because if it is a dispute of right which is enshrined in our Constitution of Zimbabwe, then the employee can even appeal further to the Supreme Court to determine whether this right of an employee is it is enshrined in the Constitution. Is it been violated? Is it in is the employer failed to exercise is required in the law? So those are the things we will be exploring in terms of. But in terms of our Constitution of Zimbabwe being the principal law which governs in terms of matters in terms of employment, it covers in terms of who are supposed to be covered under Section 65, but it further goes to say many, if we are talking now of the uniformed forces, in terms of the army, the police, they are not covered under Section 65 of our Constitution of Zimbabwe. That's in terms of the brief. Who is covered and who is not covered, which means any other sectors who are not, which doesn't fall under the uniformed forces, they are covered under this Section 65 of the Constitution of Zimbabwe. That's in terms of the overview. Then in terms of also the guideline in terms of our employment matters, we also have, beside the Constitution of Zimbabwe and the Labor Act, we also have the various collective bargaining agreements for each specific industry. Like we have for the commercial sector, they've got their National Employment Council for the commercial sector, which comes out with the regulations or basic conditions of employment in that sector. We also, for the energy industry, they've got their National Employment Council. We also have for the motor industry, they've got their own employment council. We also have for the construction that they've got their employment council. So those employment councils or those collective bargaining coming through those employment councils, they are also binding to every employer who falls under that specific industry or terms who are registered also under that industry, which means even if you're not registered again, if you fall under that industry, maybe you offer security services, then you are not registered under the National Employment Council for the security services, which means you also violating in terms of the requirements. And also, let's say you are operating a school, a college, you are operating a training sector or as an NGO, you are not registered under the welfare NEC, which means you are also violating the legislation. Then in terms of that, we also have sectoral instruments which also guide us in terms of the employment sector, like we have got the National Code of Conduct, the SI 15 of 2006, which also guide us, which operate at the National Code of Conduct for those organizations who don't fall under any specific NEC, and also who do not have a registered code of conduct for their respective organizations. They mainly use the National Code of Conduct. Then we also have the common law practice and also the court judgments, which also guide in terms of the relationship between of employment in the employment sector. Mainly, all employees are protected, be they casual workers, they are fixed-term workers, they are contract employees, or the employees with a contract without limit. Those are who are referred mainly as permanent employees. All nature of employees, they are covered or they are protected under the Labor Act, or also which falls under Section 65 of the Constitution of Zimbabwe, which means even a domestic worker, they are also referred as employees. They are also covered under the Labor Relations Act in Zimbabwe. So I've been just highlighting in terms of the Constitution of Zimbabwe, the 2013 Constitution of Zimbabwe, Section 65, Part 1 of the Constitution of Zimbabwe, whereby we say every employee has the right to fair and safe labor practice and standards, and the right to a fair or reasonable wage. That's what our Constitution says in terms of the relationship or the conditions of employment in the employment sector, to say every employee has got the right to a fair or a safety labor practice, which means the environment, our operations, how we treat our employees, how we come up with our contract of employment, how we engage them, how we terminate them, which means every employee has the right to a fair and a safe practice in terms of the labor relations, and even the standards, the work environment, in terms of safety, in terms of the environment the employee is working on, the right of the employee, which is also enshrined in the Constitution of Zimbabwe. When an employee feels usually those rights have been infringed, or the conditions of employment are not in line or are not in sync with the Constitution of the Labor Relations Act, usually they may raise as a grievance, which we'll address later on. How would we address grievances in the employment environment? If the employee raise a grievance or any they are assumed to be an unfair labor practice, and also employees they've got right to a fair and a reasonable wage. But the question will remain, what constitutes a fair and a reasonable wage in our economy? That would be another issue of discussion. How would we constitute whether this is a fair or a reasonable wage for an employee, considering nowadays many employees, I think they are falling below the proper bottom line, which means, do we consider that as a fair and reasonable wage for our employees? Which means, in that discussing that, as an employer, it will be now the responsibility of the employer also to assess whether what they are giving or their remunerating their employees, is it fair or reasonable for them to provide the services they will be providing in an employment sector. Then that's the brief in terms of our constitution. Mainly we dwell in terms of section 65, in terms of constitution, subsection 1, which focus in terms of labor relations. Then if we now go to our Labor Relations Act, Labor Act in Zimbabwe, which now deals with now the detailed issues, maybe taken from our constitution. What are the fundamental rights of an employee, and what are the issues which can contribute to unfair labor practice by the employer within an employment sector. Then we'll focus in terms of that. Then there are also unfair labor practice from a trade union, and there are also unfair labor practice from even a labor officer. There are issues can be determined to be unfair labor practice, but mainly we want to focus in terms of the employer and the employee, and also other close factors which are affected in terms of the employment relations. Then if I focus in terms of the part 2 of our Labor Act, 28.01, these are the fundamental rights of an employee in an employment sector.
Moreblessing.
Yes.
Moreblessing. May I interject? As you were speaking about the Constitution of Zimbabwe,
Yes.
I took note of a number of issues that you referred to, which might be of concern to our mentees. They are trying to run small companies. Sometimes maybe they just have 5 people within the organization. It's the owner and maybe 3 employees. Are there any, from the way you put this across the Constitution of Zimbabwe, which is trying to safeguard the rights of the employees? So it's more of looking at the rights, because the statement, if you could go back to the slide where you highlighted the next slide. Yes, it says rights to fair and safe labor practices and standards, and the right to fair and reasonable wage. So am I correct in deducing this as this is speaking directly to the employer, that the employees that they have must have a right, or do actually have a right, to safe and labor, fair and labor practices, and a right to a fair wage? Will I be correct in deducing that from this statement?
Quite correct. Quite correct.
So this
because,
is okay, you can proceed.
Yeah, what I want to try to elaborate is that when we are looking in terms of the issue of there's a power imbalance between an employer and an employee, because usually mainly it's the employee who seeks employment and the employer is the ones who hires. So in terms of the power, economical power, the employer has got more power to the employee. So when the Constitution of the Labor Act comes in, they are trying to protect the weaker part, though even though they are also cover issues to do with the employer, because employers also they are covered from other issues. They've got their Companies Act, there are other various acts which covers the employers. But mainly what they are saying is they want to protect the weaker part, because the weaker part mainly is the one who can be who can be disadvantaged. So when the constitution also address the issue, address issues to do with everyone, but mainly focus on the employee, that the employee being the weaker part, coming into an agreement from the weaker perspective, the employee has to be protected. One, they have to protect from the issue of being given what you call the right to a fair or safe labor practice, because at times you are getting in an employment sector, you are said, let's say in the construction industry, the employer want to build a building, but the employee is being forced to go into practice the building without a helmet, without the necessary protective clothing. So that's why the labor it comes in. If you are an employer, you are providing a service, you need the labor to do the services. You have to provide the fair and safe labor practice, the fair, safe environment, at least being a fair, provide the helmet for the employee in the case they are injured, they are not, they no fatal injuries, and also the safe environment which doesn't affect the health or the welfare of the employee in the long run. I think that's in just in summary, that's what I can say to say the employee is coming in an agreement as a weaker part, and the employer being the stronger part. Just like if you are getting an agreement with a weaker part, mainly the law protects the weaker part. It's just like in our constitution of Zimbabwe, if a person, a human being, gets involved in a relationship with a minor who is below the age of 18, the law says the relationship is now in void because this person cannot reason, cannot have not reached the age of majority. So whoever engaged in a relationship with that person, they are violating the law. That's also where the perspective comes from, that the employee is the weaker part, so they should be given fair, safe labor practice, and also even the standards, the environment they are working at, they should be also fair, reasonable for them to continue selling their labor in terms of our laws.
That's quite enlightening. However, if we put things into context, the Constitution of Zimbabwe was written in 2013. Maybe at that time, some of our mentees were still at school, and now they have started going out there. They call it kungwava ngwava these days. You don't start a formal organization, you just start from somewhere. And it's primarily maybe an individually run organization. At the beginning, I'm just myself, I'm the MD, I'm the salesperson, I'm the sweeper. But eventually I get overwhelmed and I realize that I need to bring in other people. Are there any incentives, or it's more of an obligation? So the question is, if I am a startup, because this is what most of our mentees are like, some of them are successful startups, some of them are still struggling to stand on their feet. They are looking at every cost, and they are looking at every opportunity to try and leverage on it so that they can eke out a living. Do you think the Constitution does also promote, what are the incentives for my small organization, my 3 people organization, to follow the Constitution, other than what the law requires me to do? Yes, the
Okay.
Maybe in brief, before you proceed to the next slide.
Thank you so much, Ruben, for that. Quite a good question. The incentive with regard to employers, basically, let's say I'll start with maybe a reasonable wage. or a fair wage. Let's say you fall in the commercial sector, you have just started a business, you've got 3 employees, you may not be able to afford the minimum which has been set by the NEC. Let's say the NEC has said now the minimum wage is for the lowest person 30,000. Maybe you cannot be able to afford with the revenue or the which you are raising at that moment. Usually the law provides a situation whereby you can approach the respective NEC, you apply for a waiver to say, I am Moreblessing Holdings. This is my income. You have gazetted this wage for the minimum at the moment. I may not be afford. This is my cash flows. This is my income statement. You submit to the NEC. Usually the NEC, after taking considerations of your submissions, they can waiver for you to pay certain salaries, the minimum salaries for a specific period, to give you a reasonable time to able to recover, or maybe to able to raise enough funds so that you'll be able to meet the required NEC, which means every industry, if you fall in a specific industry, you can apply for a waiver in that particular NEC, so that they will grant you the waiver. Once they've been granted the waiver, which means they've done the legal process in terms of moving away from paying the minimum for that particular industry. But if you continue operating without seeking for the waiver, which means the law will say you are violating the legislation, so you may be penalized for that. So the best way is there are reasonable charges for any organization, even a startup employer, to be a member of a particular NEC, so that you enjoy those benefits. In the event you are not in the capacity to be able to pay, you approach them in writing, and they also can give you the waiver, because in any environment there are also startups who are starting, they may not be able to meet the minimum requirements. So the waiver can also apply if you approach the respective NEC, because NECs, they are also registered under the Labor Act. They recognize, if you check from my first highlight, that in national employment councils, they are involved in the collective bargaining process for specific industry. So that's where they come in to consider certain issues within the specific industry, and also grant waiver with regard to that. Maybe it is in terms of the work environment. Then you can approach the National Social Security Authority, their safety department, and say, this is the work environment I'm providing. Maybe you are not able to provide certain conditions. They will give you maybe a temporary permit, or so that whilst you are working out on certain issues, you'll be given the green light to operate. Unlike when you wait for them to come to your premises, they identify you are violating the legal requirements, which means the first thing they will do is they will penalize you. So the best issues for any startup, whether an organization, is to find out prior to register, prior to operation, just do an analysis and research in terms of the environment you're operating in. What are the requirements for this specific industry? Which are the NEC which I fall under this industry? And you make relations with them, so that when you are going on as a startup, you are also you are engaging them where you are not meeting the minimum standards. You engage them, you write to them. The best way is to write to them in a formal way, because the formal way of communication is where that to submit in writing. You give your facts or your supporting documentation. They consider that many organizations, they are also given the waiver in terms of that, when they are not meeting the minimum requirements which has been set by a respective NEC, or by in terms of the Labor Act. I'm not sure if I've clarified that clearly.
Thank you, Moreblessing. I think you have done justice to it. I think the key take-up, or the key point there, is that everybody can be accommodated. You just have to make sure that you engage the respective offices, so that you are not found in breach. The law does allow for variations, but it just has to be formalized. So that should be good enough for our startups. You can proceed. Thank you very much for that. Our time, we are already 45 minutes into our presentation, so we need to speed up. Thank you.
Okay, that's I'll speed up because some of the issue I've covered on the preliminary, they are also when we go on, it will be just maybe running through them because the issue of the rights, of discrimination, they are covered primarily from the Constitution and the fundamental rights of the employment sector. Okay, so the from the Labor Act, the Part 2 for Labor Act just give in terms of what are the fundamental rights of the employee. Every employee is entitled to a membership to a trade union or a workers' committee, which means if you are falling under a specific industry, the employee is there for the right to membership, which we've got to our constitution. Those are the rights to freedom of association, which means every employee, every human being with rights to freedom of association. So when I come to the Labor Act, which means every employee has right to a membership to a trade union or a workers' committee, which means those employees, they for that right. They also have right to a prohibition of forced labor, which means employees should not be subjected to forced labor, whether you employ a person who is below the 16 years under our Labor Act. It doesn't allow to employ a person who is below the 16 years. It's almost forced labor because you are employing a minor. Then also employees are also protection against discrimination. Discrimination will come in many ways. It's a discrimination in terms of recruitment processes, discrimination in terms of promotion, discrimination in terms of adverts, discrimination in terms of even secondment for those other women who have been seconded, or in terms of termination. Let's say, for example, I give example for an advert, whereby you put your advert, whereby say, put your job specification and say, only male employee, only prospective male can apply for this position. Under the Labor Act, it's tantamount to discrimination because you should not discrimination against gender, you should not discriminate against race, you should not discriminate against color, you should not discriminate against any grounds, which means every person should be given a fair in terms of applying for a job, which means no discrimination should be exercised upon every employee, whether it's promotions, hearing, it's acting positions, it's giving a position, which means every person, even in the sector, whereby you've got 5 employees on the same level, maybe you've got 5 operators, then you want to promote employee, it all depends on the policy of the employer, but all the employees, they may also need to be given a fair opportunity if you want to promote a senior position, which means that's why you see organizations, some advertise, even have internal adverts. What they're simply saying, they are giving every employee the opportunity to apply rather than to discriminate certain employees, except whereby the policies are clear, whereby in terms of the performance of one employee has been above other employees, then you can, it's not discrimination in that case. Then also, employees, they have protected against the right to fair labor standards which have highlighted earlier on, the issue in terms of the workplace. There's those issues they have to, employees, they have to be given a fair workplace in terms of the standards of working, the safety issues in terms of the employment. Then also the right to democracy in the workplace, which means the issue should be members of the workers' committee, the employee, they've got that right, whether they want to be a member of the workers' committee, the members of a trade union, those are the rights through democracy for an employee at the workplace. No employer should say, you should not be a member of any trade union or any the workers' committee within the work environment. Then there are the issue in terms of discrimination, which employers have to avoid. In terms of the advert of employment, you have to see that your advert, if you're advertising, it doesn't discriminate any class, any race, any particular section of employees.
Moreblessing, may I interject? Let's go back to the previous slide. I've got 3 questions that come up in relation to our startups and small businesses that we are currently running. The first one is, can I, if as an organization I have not subscribed to any collective bargaining agreement or any NEC, which is most likely the situation with most of our small businesses, am I losing out on anything? That's the first question. Is my organization? So I'm going to ask
correct.
I'm going to ask the 3 questions and then you can then answer them in one go.
Okay.
So the first one is, like I've said, if I'm not part of any NEC, am I losing out on anything? Then the second one is on the part of the workers. They are saying that the employees have a right to join a trade union or join a workers' committee. Am I forced to allow workers' committees to be formed within my organization if I don't subscribe to any NEC? Am I forced to allow my employees to register for a certain trade union if I'm not part of any NEC as an organization? And then the last question is, as a small or startup business, sometimes maybe I'm actually running my business from home, and maybe I've got a small sister who's below 16, but they can help with the activities like sweeping or maybe handle some of the paperwork. Am I said to be using forced labor? Can such a staff member go and report me if they are my daughter or my sister? Am I supposed to give them a fair wage? They are already working for the business that's giving them food, it's putting food on their plate. I can't afford to employ somebody. They are already there. Am I said to be doing or using forced labor? So those are the 3 questions that I want you to respond to.
Okay, thank you so much, Ruben, for that. Hello?
Yes, I can hear you, Moreblessing.
Yes. Okay. Are you done?
Yes, I'm done for now. On this slide, those are the questions that I had. You can proceed to answer.
Okay.
And then you can then proceed with the first.
Okay, I'll start with the first one, being part of the NEC. It's a requirement whereby if you fall under a certain industry, which means to be a member of the National Employment Council. One way you are losing out is you are losing out in terms of information, because the employees you are employing usually in regard to the NEC, they've got their grading system. They've got in terms of their the basic roles for the jobs and the grading system they use, which means you are losing out in terms of information in regard to minimum salaries, which has been gazetted. I'll give you an example. If you are falling under a commercial sector and you are not registered, the moment the NEC realize you're not registered, they can penalize you for failure to register if you fall under that specific industry. So, which means both they are governed or they are regulated under the Labor Act. So, your failure to register is also part of the failure to comply, which means you are required to register with a particular National Employment Council, which represent that sector. Because if you check in terms of the Labor Act, it gives provision in terms of registration of the National Employment Councils for that specific, which means once an employment council has been registered, it is given the mandate to regulate everyone, every employer who operate within their environment, or we operate within their operations. So, which means you are falling under that particular NEC. So you're losing out in terms of any information. You are losing out in terms of mainly information with regard to what is happening within the industry in that part. Then also, you asked in terms of the workers' rights to be a member of trade union or workers' committee. Our Labor Act again, if you check in terms of part 4 of the part 6 of the Labor Act, it gives the conditions that every employer or employment setup there should be a workers' committee in that setup, which means workers' committees, they are there to advance the issues or the issue to do with the employees. So every employer, we have got mainly 10 employees above. I will check in terms of the number of employees. They are supposed to have a workers' committee. But even if you have got 2 employees, if an employee decides to be a member of a trade union, which falls under their particular employment council, they are not they've got that right, that the freedom of association which is governed by our constitution of Zimbabwe. So as an employer, you have no right to say you cannot be a member of a trade union. You have no right to that. And every employer in any setup, they should facilitate for their employees to form a workers' committee in every employment sector, which means even if you have 10 employees, you should facilitate for for your employees to form a workers' committee, which means they discuss their issues. They have to sort out the time in terms of discussing their issues within the period of employment. With regard to their issues, either their grievances, they concern, they may not have even to collective bargaining, which means you can even negotiate for remuneration with your workers committee. But if that remuneration falls below the NEC again, it will be a violation of the set standards. Then also you highlight the issue with regard to issue of employment of relatives. A contract of employment, I think we'll highlight that as we go on. A contract of employment, even if I offer my young brother employment to say, can you come and work for me? It's a verbal contract of employment I've offered that person. Under the Labor Act, it's a contract of employment. If my young brother or my sister decides to sue me to say I was not being paid the fair salary in terms of that industry, I'll be held accountable to that, which means a contract of employment can be in writing or cannot be in writing. And violating even contract of employment as per the agreement is also a violation of the labor rules. And even if the employee signed for a minimum salary, which is the salary which is below the minimum set for that particular industry, it's also a violation of the law, unless I've sought the waiver to the respective body to get the waiver to say I'm not able to pay the minimum for that particular period. So a contract of employment is irrespective of it's your brother, it's your sister, it's your cousin, as long as that person is giving you labor services in terms of selling their time, and you are also paying the wage, which means a contract of employment exists between the two of you. That's where the labor or the constitution comes in to say it's coming to protect those relationships whereby someone is benefiting from the labor, but at the same time not giving a fair or a fair labor practice or a fair in terms of wage to that person giving that labor in that respective function.
Oh, thank you, more blessing. You can proceed. I think that's quite insightful and should help us in the long run.
Okay, that's fine. I'll just run through this in terms of discrimination. That in terms of payment processes, that means every person, if you are advertising, you have to give a fair advantage to everyone in terms of applying. In terms of creation and classification of abolition of jobs, every person have to be given an equal opportunity. Also, in terms of determination of wages and salaries, whatever the pension, you cannot say you have got two accountants or you have got two operators, then the other one is being given 10,000, then that one given 15,000 without any justification. If it is either performance related or whatever, then the person can raise a grievance. And that grievance, if the person, they can take that grievance to the labor. If it is below the minimum, that means as an employer, you are also held accountable in terms of that. Then also in terms of promotion, retrenchment, even if you are training employees, you have to have reasons why you are training ABCD other than ABCD, which means usually the law requires every documentation to having a performance management system. You have to submit this person has not been performing for this period, so I'll train this person other than this one. So those information should be always available. That comes to an interesting part in terms of employment. Are we keeping records of employment in terms of what we do in terms of employment? Which means if you are doing performance appraisal, if you are doing employee the committee offense, as an employer, you have to keep the records. In the event an employee committed an offense, they have to go through a process of a disciplinary. So in the event maybe you are promoting an employee where they've got they are still within the time of suspension or the time of you have to highlight the reasons why you are promoting this person other than the other person. Okay, sorry, I think my slides just okay. Okay, let me just try to think the font here just becomes so tiny. Don't also, yeah, what constitutes unfair labor practice to an employer by an employer? Usually, when you prevents or hinders or obstruct an employee in the exercise of any right conferred upon him in terms of Part 2. The Part 2 has been talking of in terms of being a member of the union, exercising their right. That's it's unfair labor practice according to the Labor Act, Part 3 of the Labor Act, whereby say if you prevents, hinder, or obstruct an employee in terms of exercising their right, then you are practicing unfair labor practice. Also, you contravenes any provision of the Section 2 of the Part 2 in terms of the standards of employment. You are also
Sorry, can I interject, Blessing?
quite
Blessing,
correct.
can you maybe put your slides into presentation mode? You can go to the tab that's written slideshow there. At the top there, they should just above the size of the lettering, there is a tab that's written slideshow
Okay,
on the
okay,
menu bar.
okay, that's fine. That's
Yes.
okay.
And then
Okay,
you can say from current slide,
yeah, from current, that's fine. Also, that it shows the
the
letters
bigger
that
font,
become
yes.
okay, that's fine. It's okay. So
Yes, that
let's
should be better now.
thank you so much.
You're
So
welcome.
if an employer refuses to negotiate in good faith with the workers' committee or a trade union which has been duly formed, which is authorized in terms of the act, it's considered as unfair labor practice. When even if the employer failed to cooperate with any the employee or the trade union or the NEC under the Labor Act, it's considered unfair labor practice. And also, which means if you fail to have a collective bargaining agreement with your employees, maybe they've engaged you, they've got a workers' committee, or some of the employees they've engaged you with the grievance in terms of their salaries. And if it remains unresolved, it becomes an unfair labor practice. Then also, uh, if you fail to abide by any decision by any employment council with regard to employees or with regard to any employee who falls within your organization under the Labor Act, also is considered unfair labor practice. So the issue of unfair labor practice comes also from the issue to say, have you prevented, have you hindered, have you obstructed your employee from exercising their right as per the Labor Act, within the right to a fair wage, the right to a fair work environment, the right to negotiate in good faith, the right to freedom of association, which means as an employer, you have also violated the laws. Then also there's an issue whereby the employer, maybe in terms of want to recruit or promote, they demands from any employee or prospective employee any sexual favors as conditions of employment in terms of engagement, or what the employee or feels to be unwelcome advance or unwelcome remarks or unwelcome comments from the prospective employer or from the whether it's the manager or the supervisor who is involved in that, it constitutes to unfair labor practice. If the employee make the submission and it's determined to be unfair labor practice when there's an evidence, which means it's tantamount also to unfair labor practice. Okay, then we also focus in terms of the contract and termination, the contract of employment. I think we're discussing the issue of contract of employment in terms of our contract of employment, which means though our Labor Act doesn't state to a contract should be reduced to writing, but Section 12 of the Labor Act further highlight that there are certain issues which should be stipulated in a contract of employment, which means even though if you don't reduce your contract of employment in terms in writing, but if you have even if it is verbal, it's a contract of employment. But the Labor Act further to say there are certain sections, certain issues which should be put in a contract of employment, which means there are issues which have to be reduced in writing, which are like the name and the address of the employer, uh, the remuneration you're supposed to give to the employee should be stated in writing. The issue to do with the probation period should be written. The issue to do with also the leave provision should be clarified in how it's computed. the issue, if the employer are giving them bonus, they have to indicate it. If there's no bonus, also have to indicate in that agreement to say you'll be entitled to bonus or you're not be entitled, they will not any bonus. So those issues, they are also have to be highlighted as per the Labor Act, which means putting everything in writing, it also protects the employer in the event from an employee make a substantial claims which were not addressed in the contract of employment. In the event an employee claims that I was earning 15,000, when the contract of employment say you were earning 10,000, which means if the employer submit evidence that this is the agreement which we entered in the employee and they agreed, as long it is above, it is within the minimum of that sector, then the employer will obviously win the case. But there is no document to prove. Usually, the law gives the benefit of doubt to the person who is claiming, as long they can give substantial evidence to prove that they were being unfairly treated. Then, in terms of the contract of employment within the sector, which means we have got various contracts in our which the Labor Act, which we operate in various sectors, which means we've got short-term contracts, we've got a contract for a period of maybe 1 day to up to 3 months, in case which may be for what we call the casual laborers, which is mainly given a 24-hour notice or 1 day notice in terms of you want to terminate that contract. Then we have also contract for a period of 3 months to 6 months, but less than 6 months. Usually, when you terminate that contract, a 2 weeks notice is required for you to terminate that contract. Then we've got a contract which is for a period of 6 months, but it's less than 1 year. You are required to terminate that contract on 1 month's notice. Then for a contract for more than a year, but less than 2 years, you are supposed to give a 2 months notice, either part. Then a contract of 3 months, a contract for a period of 2 years and above, the notice period is 3 months, which means either part, when they want to terminate the contract, they should give that notice period. So that's the requirement in terms of our labor. So in the case an employer or an employee, they've given you are on a contract without limit, you have given your employer a 1 month notice, which means it's not suffice in terms of giving that notice period. So which means that's the requirement in terms of the legislation, in terms of the notice period. But besides that, the law allows for a waiver of a notice period from either part in the event the employee or the other part does not give the notice period. But when the notice period mainly is being given by the employer, if you check in terms of 12C of the Labor Act, subsection 12C, it highlights that in the event the termination is instigated by the employer, when the required notice period is not being given, the employer is supposed to compensate the employee with regard to the required, in line with the required notice period. That's in terms of the guideline, in terms of our Labor Act, but either part is required to give the required notice in terms of our Labor Act. Then also,
a brief question on the termination and the employer having an obligation to pay for the notice period that then they did not grant the staff member. The current scenario in our environment is that organizations have tended to give allowances which are higher than the basic salary. So what's the obligation to the organization? Is the organization obligated to pay the salary plus allowances, or the organization is now just only obligated to pay the basic salary minus the allowances? Where does the obligation with the organization sit?
Okay, it's now determined, it depends with the type of allowance the organization has been given. But if the law determines that the allowance they have been given to the employee, they've now a legitimate expectation upon them, it might be very tricky for the organization to withhold those benefits when they want to give notice. But the basic trend in the industry is whereby organizations they pay the notice period based on the basic. But the organizations which are quite a bit wise at the times, they pay even including the other benefits which have been become like a regular benefits. irregular benefits, like you've been giving your employee an acting allowance, those irregular benefits, there's no mandate to give them. But if there have been regular benefits the employee was entitled to, it's a pension, it's medical aid, usually those benefits you have also to give to be part of your notice paid to that respective employee.
Thank you for clarifying that. We don't want to stay there for long. We have 45 minutes to go.
Okay, that's fine. Then, in terms of termination of employee again, when you're terminating employee, it's either you have to be in line with the code of conduct, or in terms of the employment code of that specific industry. That means if you fall under any specific NEC, when you're terminating employees, you have to follow that the code of that particular industry in terms of termination. Then there's a dilemma comes whereby you don't fall under any particular industry, which means you have to approach the Minister of Labor when you want to terminate your employees in terms of maybe you make your employee redundant, or you want to change your employee. You have to first approach the Minister of Labor, which means in terms of your leeway, at times it may be limited, unlike if you go through the NEC, if you are agreed by the NEC, you proceed to the Minister of Labor, which means you've got a little bit of room in terms of negotiation and also appealing. Unlike when you go to the Minister of Labor straight, which means the Labor Code determines, then you are also remain to go to the High Court in terms of determination, which means your leeway is also reduced in terms of that. Then also you can agree to terminate a code of employment by mutual agreeing, employer and employee agreeing to say, okay, let's terminate. Once it's been signed in writing by both parties, you are also allowed, if any, to terminate it. Then if the employees on a fixed term period, you are also, when the period of contracts come to an expiry, you are allowed to, it's not an offense to not renew it if it's a fixed term contract. It's allowed under the Labor Act. It's been giving notice just a courtesy when the person is employed under a fixed term contract. It's normally a courtesy, but not required under law. But normally it's a courtesy done by the employer. Then when you are training, usually you have to follow Section C of the training. Means you have to have an agreement by a workers' committee or a workers' council. Then you proceed, that agreement is writing, are submitted to the retrenchment board. From the retrenchment board, now once they've approved it, you do other process in terms of your retrenchment. Then also you have to take note, when an employee is being provided accommodation, let's say an employee has committed an offense or terminated an employee. Let's say the employee was being paid on a monthly basis. Then you terminate the employee on the 10th. The Labor Act says the employee should vacate the accommodation before at the end of the particular month. You cannot say the employee, because I have terminated the employee with you today, you have to move out from my accommodation. The Labor Act subsection 12.6 allows that employee be given up the end of the month of the notice period to vacate the casualization. What are its challenges? Casualization mainly is the re-engagement for employee on short-term contracts when clearly there is work of a permanent nature in that particular organization. That's what we call casualization. Just like you employ casual laborers for a particular period for 1 year, you are renewing a contract for 1 month, or 2 weeks, you are renewing contract continuously, you are giving them contract. That's called casualization. Even a fixed term contract, you give an employee a fixed term contract, when you renew those contracts continuously, it's called casualization, because the law will determine that the work is available, but you want to take advantage of the employee by continuously giving them short-term contracts, because maybe the employer is avoiding to pay other benefits associated with the permanent nature, which means the employer is trying to seek avoiding consequences of permanent employment by giving employees short-term contracts. So in the event the employer has taken the issue to court, then the employer, you are found liable in terms of employing renewing contracts continuously. Many people, they do it, but it's casualization, the violation of the act in terms of that. There's a critical case in terms of Lifestyle Holdings against one of the team in 2014, whereby they'd renewed, they'd given their employees contracts for a period of more than 5 years, giving them contracts, renewing, terminating them. Then the employee, when they were terminated, they said, we're on a permanent employment because we've developed what we call legitimate expectation. When the employees developed legitimate expectation, the court found that there was clearly a violation of the law from the employer who was engaging on a short-term basis in terms to avoid payment of benefits or to their employees. That's called casualization, whereby you continuously renew contracts of employment for employees to take advantage of the employees, which means the employer is taking advantage of the employees in terms of giving them short-term contract. When you see you have got a permanent work which is of permanent nature, I'll prefer to give that employee a contract without limit. Or when you say to, okay, you are a startup, maybe you think you may operate for 1 year. It's better you give an employee a contract for 6 months. You make your assessment of your business. Then after 6 months, you can say, okay, do I need to continue operating or not? If you see your business environment allows you to continue operating, I would prefer to give that employee a contract of a permanent nature. But you give your employee, you give few employees, then you employ a few employees at a time so that you assess your cost and benefit, you do a cost to benefit analysis in terms of your employment. Rather than to employ many employees on contracts, at the end of the day, you increase your in terms of reliability. Then the key issue at times which determines whether you are also practicing casualization is whereby you continuously change employees. Today you have employed John, Peter, giving them short-term contracts continuously, and there's no change of job description, there's no change of work environment. It can be tantamount also to casualization. But the good practice, every employer, every organization is good. It's the best practice to have your job descriptions, which shows the activities to be done by the employee, a list of activities to be done by the employee, the duties performed by the employee, and also who does the employee report to, or what are the responsibilities of the employees, and which code of conduct apply to that particular employee. It also clarifies the issue of punctuality, discipline, and safety in terms of procedure of employment. Those issues should also be clarified. Then many job specifications are those statements you should draw when you want to recruit employees, which you show in terms of the characteristics or qualifications required to perform a certain job. Job knowledge, skills, abilities, or any other competence the employee may have. Those are our job specifications. So every employer, if like every startup in a clean sheet whereby you have a job description, you want to employ an operator, you want to employ an admin assistant, draw a job description for that particular job. What are these roles or roles? So you clarify those issues so that you don't have any dispute in the long run with regard to your employees. Then we want focus in terms of overview in terms of the basic salary in Zimbabwe, whereby our basic salary in Zimbabwe, they are either grade based, which means salary men they determined based on the particular grade, or also there are also NEC negotiated for a particular industry.
Moreblessing, sorry,
Yes.
sorry to check you back a bit. Can you just go back to the previous slide?
That's fine.
Normally in our startups,
Yes.
if I were to write a job specification or a job description, it might be very difficult even to assign a title to somebody, because maybe the same person who's doing receptionist duties is also doing my record keeping. That very same person is also doing the housekeeping for the place, and they are sometimes maybe loading the trucks and offloading. Under such circumstances, how do you advise me to go about it? How do I write a job description for such a person when they are doing research and everything that's available at that time? I can't afford to employ a person who's doing loading. I can't afford to employ a person who's doing receptionist duties. I'm just employing somebody to come in and help in anything and everything that is a reason. How do I go about that? It's maybe not necessarily a legal issue, but I also maybe want to help this employee of mine so that they get more focused. How do I write a job description for such a scrambled job?
Okay, that's fine. I think the best way when you are planning to say you want to, there are short-term work whereby you say, this is not a permanent job. Maybe today Moreblessing has been called to say, come and offload a truck. It's irregular. It is sort of a permanent nature. That cannot be put in my job description. But there are roles which I perform on daily basis, which you know that I need a person to do administrative work. The person maybe is an administrative assistant, does partly accounting, partly HR issues, partly to do buying, partly to do that, which means you can come up with the role of that person responsible for the administrative work. Then we have got also other people who may do the other work, maybe the issue to do, maybe give example, maybe offloading and other things, whereby you may not need a permanent person on a daily basis. That's why I now hire a casual labor to say, okay, I'm employing you for 2 days to do this work, so that you avoid the issues, the complexity or the issue to do with the violation of the legal requirements. But for administrative work, a person can cover HR, accounting, buying, or other administrative issue, assisting in the office. Then here and there, when the work arises, the person can come and assist here and there. It's usually normal, but when the task becomes a repetitive task, the person can claim that person to be included in their job description. But the best issue is also, that's why I say the advantage of joining NECs, usually they give you the guidelines in terms of the roles for any particular job. You are a startup, you can come up with an administrative assistant, the person covering all those functions in your setup, so that even in terms of your planning, when you start as a startup planning your things, it will give you even a greater guideline. Because when you are starting up, when your things are in order, you are planning, you've come up with a draft organogram of your organization, you are the MD, maybe the wife is the deputy MD. We want an admin assistant assisting in terms of running other things. That's fine. So that when you are growing as an organization, you have a clear vision and also direction where you are going in terms of organization. Because when your organization is setting up, it's got its mission, its vision, and also how the way it's supposed to go. So the organogram also is part of the direction the organization is going towards. If you're expanding, you say, I need now an additional person because I'm growing in terms of organization. The organization is not growing.
Thank you. Thank you. You can proceed.
Okay, that's fine. Though are the basis in terms of the basic salaries, mainly they are grade based. We've got the NEC negotiated salaries, whereby we highlight that if you want to seek a waiver, you can approach the respective NEC in terms of that. When you also want to increase your salaries, maybe you want to go above the NEC, you can just benchmark against the market to see how the market doing in terms of the salaries. Also, mainly the challenge in terms of Zimbabwe, many of our salaries, they are not performance based. The collective bargaining process. People they bargain based on the grade or on the or on the level of the individual in the organization, not because of performance. That one of the challenge we are experiencing in our country. One of the issue which need to be worked on. That's why I trying to highlight to say our combat system mainly is maybe it's based on the wage. It's not linked to productivity. The issue we've been highlighting that it's better if our laws were in terms of allowing employers to pay based on productivity, but our laws based on the wage on the grade of an individual. That's how our wages are negotiated. Trends usually in our sector they are determined by the economic staff of each country. That's why in Zimbabwe mainly we at times employees say we are on the lower level in terms of our salaries, our wages is based on our economic status of a country. Then if we check in terms of employees mainly, our challenge mainly we are experiencing here is whereby you give an employee a salary of maybe 20,000. Mainly the greater part, 20% and above of that salary is going towards pay as you earn. That's an even field whereby that's why employee times whether the salary is going up, they may not uh, be satisfied with that salary. Then our focus in terms of some of the legal compliance issues which we have to deal with in our organization. We have
If
to
I may,
register.
if I may interject, let's go back to the payee issues. So
Yes,
as a startup business, maybe I'm not even tax cleared. Am I supposed to then remit payee to the government if I am
quite
paying my
correct.
staff?
Thank you so much. Let me address on this next slide. I'll address this one on this next slide, whereby I talk of similar issues. As long we are operating as an organization, the best approach is to register. Once you are earning an income, both an income is for either for an individual or you are running a business. If you are running a business selling, which means you have to register. Even an individual have to register with Zimra. If you are earning income as an individual, as a consultant, I have to register with Zimra so that I submit my tax returns. So as an organization, whether you're a startup, a sole trader, a private organization, you have to register. The moment you register, you are performing your business, you have to register, because the moment Zimra found that you are not complying, you are selling and you are not paying taxes, you will be penalized. Especially for pay as you earn, the penalty for pay as you earn, for failure to remit pay as you earn, is 100% the penalty. So the penalty is quite heavy for the organization. So it's better to comply than to be penalized 100% of what you're supposed to have paid. So every organization, the best way is to register. You meet your requirements. For your employees, you deduct pay as you earn from them. You submit to the Zimra. Because it's one of the requirements, even if you're applying for the ITF 260 return, you have to show them the returns for the particular period. So even if a startup, the best way is to comply. Once you have complied, it helps it. Even if you want to submit tenders to the government, to other registered organizations, they always need your tax clearance. So compliance is very critical for any startup in terms of business. Then you have also employed employees. You have to, every employee is required to be registered under NASA, except if you are an informal trader, then you are excluded. If you are a registered employer, you have to register with NASA, and your employees, which means you have to make deductions 4.5%. That which means if an employee works for 17 days and above, NASA have to be deducted from them. And even if for employees who have worked for 2 days or 3 days, the employer is required under NASA to contribute what we call Workers' Compensation Insurable Fund, which saves in the event your employee has been injured at work. If the employee is injured at work, if you are registered under the Workers' Compensation Insurable Fund, the payment, because our labor law says an employee, if he is injured at work, the employer is supposed to pay 90 days on full pay, that's sick leave, which means as an employer, the days you are paying the employee while the employee is hospitalized, you can claim that from the NASA through the Workers' Compensation Insurable Fund. They will refund you that the wage you have paid to your employee during the period of incapacitation whereby the employee was hospitalized. So that the benefit of registering with NASA, because it covers for the period when the employee has been injured, hospitalized, and also you get a refund from NASA. NASA have to be registered, it's a requirement in terms of that. Then also you have to register with employer, and also except for exempt industry. Exempt industry mainly the educational sector and the NGO sector. You have to approach them to check whether your employee is exempt from Then we also have standard development levy paid to the Ministry of Finance, which is 0.5% on quarterly basis that has to be paid also, whether as long as you are an employer, that has to be paid. Then also we have to register with the NEC and pay all our NEC dues. That's the requirement in terms of our sector. Then I'll just give them this as the highlights in terms of the due dates of the payments, which I've highlighted earlier on. Pay as you earn, you have to pay on the 10th, on or before the 10th of the month, which means if I did pay as you earn for January, today, if it is the 10th, for January, I have to pay on the 10th or before, including the return. Same as for NASA, I have to pay on the 10th or before the 10th. Then for the training levy to ZimDev, you have to pay it on the 15th or prior. Then we have for the quarterly for the standard development levy, which is paid to the Ministry of Finance in Zimbabwe. Then the best way in terms of why at times organization we have to mitigate or to run away, I'll just browse this because it was just as part of our discussion. Many organization, our challenge in terms of as we start up is to have systems. Systems have to be there in place whereby we are able to have a performance culture. When you are starting with the performance culture, even if an employee, we have given an employee a 6 months contract, a fixed term contract, which means you can assess if you want to award them any remuneration based on terms of performance. You are not just benchmarking or awarding based on the in terms of no any practice. And also you are also making the employees accountable, because employees they have to be held accountable because you are paying them a wage, but they also have to be held accountable. You now have to measure them. Are they meeting the targeted results on a monthly basis or on a daily basis, so that you assess them? And if they're not meeting the targeted results under if the employer is not performing to the required standard, if the targets are smart, are reasonable, which means you can able to terminate the employee based on that. The employee is not performing for continuous period, which means you can able even to terminate the employee, because no employer will keep an employee who is failed to meet the targets or the required performance standards. Then also it helps you in terms of planning, in terms of your organization as a startup. Then one of the key issues which will fail many as we startups is in terms of the grievance management in our organizations as we start up, because they are employees, they're able to write to air their grievances. We listen to those grievances. What is a grievance? Maybe to start with, a grievance is a formal statement of complaint generally against an authority figure, a supervisor, a manager, whoever. It's a statement of complaint. If you don't address those complaints, they amount to either resentment, low productivity, or employee can resign because of those grievances. But under our Labor Act, yeah, grievances are supposed to be addressed, and as an organization, you have to have your grievance handling procedure. If every NEC, National Employment Council, they've got their code of conduct, how grievances are addressed in terms of the particular industry, then in the event grievances are not addressed, as an employer, you are also practice what we call unfair labor practice per our Labor Act, which constitutes unfair labor practice, because the grievance of the employee, if it is justified, whether it's a pet issue, the best for the employer is to address those issues so that we find a way of resolving those issues so that they don't balloon to become a bigger complaint, which maybe the employer can take to the labor court, and the employer may be found to say you violated the rights of the employee or your employer and employee agreement in terms of legislation. So the grievance employees, they have to be highlighted and also addressed based on the right protocol if you fall under a certain particular industry. Then that's in terms of disciplinary procedures. Each industry has got its own particular industry. Then if you are not falling under any particular NEC, the something that is you have to come up with your way how you are going to address those grievances, because under the Labor Act, it's not addressed in terms of how are you going to handle the grievance in an employment sector. Mainly they are governed by the particular NEC. So it will be a little bit difficult, and which means as an employer, you might found on a corner in terms of how are you going to address those grievances, which means one employee they feel the grievance, the valid grievance, you may see them taking those grievances to the labor court, which may be very tricky for the organization if they can prove that this grievance is a valid grievance and it's a violation of the rights of that particular employee in terms of the act. So which means of unfair labor practice on the part of the employer. So if you've got a grievance as a SME, sit down with the employee, talk the grievance, and find a way of addressing it so that the employee, even the employee, is fully motivated, and also you also run away from the issue of being found on the wrong side of the law in terms of our legislation. Then the critical issue is in terms of disciplinary and termination of employee in terms of the employment contract. That's one of the critical issues which we fail many as startups, which I found many people we violate in terms of employment sector. Mainly Employee, they've got a right to a fair hearing. If we go Section 69, it talks of the right to a fair hearing, which means every employee they've got a right to a fair hearing, like any other human being. You have the right to be heard, you have the right to air your views, which means it's a right which is prescribed or enshrined in our constitution of Zimbabwe. So that right, a fair hearing, what's constituted a fair just cover that as we go on the other slide, which covers in terms of what is a fair hearing. Then a right to be presumed innocent until proven guilty, which means even he is carrying a bag of cement, which means that you find the employee stealing a bag of cement is now getting out of the gate with a bag of cement. You cannot say the employee are fired because under law that employee is presumed innocent until proven guilty, which means as an employer you have to go through all the disciplinary process to dismiss that employee. Then the right to be represented, which means every employee have a right to be represented, which means even if they commit an offense, they are under the Labor Act Section 12B, give the right to be represented in any, if the employer has committed an offense, they found stealing, they have the right to bring a representative of their choice so that they can have a fair hearing in terms of the our act. Then a right to adequate notice in line with the Code of Employment assigned, which means if the employee has committed an offense, if you are bringing the employee to a hearing process, give the employee adequate notice. Not to say the employee has committed offense today, tomorrow morning I want you for a hearing process. And it can be constituted as a unfair hearing process. Normally, the law allows a period of at least 3 days so that the employee prepares to come and attend the hearing process. Anything below that, it can be considered to be unfair labor practice. And once you don't follow the process in terms of terminating the employee under the Labor Act, you may also be, even the employee has committed the offense, at times the law looks in terms of the procedure followed for you to dismiss the employee or to deal with the issue of the employee, which can be said this was unfair labor practice in terms of the employee. Employee, every employee should be dismissed in line with either a registered code of conduct for the organization, which means if you have got an organization, whether you're a startup, you're an SME, if you want to have your code of conduct, you have to register with the Ministry of Labor. Draft your code of conduct, register with the Ministry of Labor. If the code of conduct is not registered, it's not considered. Or the code of conduct of the employment sector, which is also registered with the Ministry of Labor, which means there's your registered code of conduct or the particular industry which you fall in. In the absence of the employer registered code of conduct or the employment council code of conduct, then you can only use the national code of conduct, the Statute Instruments 15 of 2006, which we mainly refer as the national charging the employee and terminating the employee in terms of the, the, the requirements of the law. Then any termination of employment without adhering to the registered code of conduct or the employment code of conduct or registered employer organization is constitute unfair labor practice. The employee can seek redress or from the court so that the issue has been addressed. Okay. Then I'll just highlight one of the issues before I go to the detail in terms of the procedure, in terms of termination the employee, in terms of the hearing, some of the ramification. I'll just clarify the issue because many startups at times we start a company 2 years, I've employed an employee, I sell the business. What are the implications of selling the business? What the Labor Act says in terms of the selling your business to another employer, or you are buying a business from another employer. You are a startup, you just buy a business from John Holdings, they've been operating for 2 years, they've got 10 employees, they're buying the business. What are the requirements of legislation? Section 16 of the Labor Act, it's just clarified that in the event of a sale of a business to another person, acquisition or major, employees according to Section 16 are automatically transferred to the new owner without loss of benefits or alteration of their benefits or any other condition of the service. Which means if you are buying a business which has been running, you are buying with it employees' liabilities. You are taking over from everything. There's no employee who should be terminated when your business is being sold, which means we are buying a new business, you take over with all the employees in that organization. Variation of terms of employment can only be done with the consent of the employee, but it has to also to seek a waiver from the employment council. If you do it with the employee, respective employee, it may also be one day the employee can change and say, I've signed this agreement under duress, and if they take it up, the employer will also be found wanting. So the issue is to address the issue, follow the right procedures, whether you start up, that's the best approach to do, so that you remain on a clean sheet. Also, when you're taking a new company, it's better to register your own company than to buy a new company, because you may take liabilities from that respective organization in terms of their benefits, in terms of their the structure, which you may not be able in your case to contain in terms of meeting their requirement in terms of the wages. Then when also you are selling your company, you have got a waste council. Usually a waste council is composed of a 50-50 representation from the employees and the employers, so that you are required to discuss with the members of the waste council or your intention of your selling your business, or engage your workers come to say, we are going to dispose your business, this is what is going to happen, so that the employees, they play part in terms of that, rather than to just maybe one day ambush say the business has already been sold. There was no consultation. In the event the employees have taken the issue to the court, even in the event the variation in terms of their benefits, the employer may be found to have violated the unfair labor practice. I'll just run through in terms of disciplinary procedures, the principle of substantive fairness. What is constituted to be fairness in terms of the hearing process? The procedure should be fair. The right of the worker is in respect to the actual
Moreblessing,
yes.
can I interject?
Thank you so much.
We are living in difficult times.
Yes.
Recently, we just woke up in January when we were gearing up for starting operations. The government then said there was a lockdown.
Yes.
At the end of January, then the lockdown was extended to 15 February. Right
Yes.
now, it's not even clear if the lockdown is going to be relaxed, and if it's going to be relaxed, who is it going to be relaxed for? It might not be relaxed for every enterprise or every industry. Under such circumstances, the employees have not necessarily done anything wrong, but at the same time, I'm not generating any revenue. I'm a startup. I have people on 6 months and a contract of a year. How do I go about it? I can't pay their salaries. I don't have any revenue over the past 2 months. What do I do under such circumstances? Am I not allowed to terminate them briefly and then rehire them when trading starts? Am I allowed not to pay them anything? Because I never got $1 in sales. The lockdown was imposed soon after New Year. What do I do? I'm a small business. I don't have any dollar. All the money that we had was used in December. What does the law say when that comes? Or is it something that is cropped up recently in the law that covers that?
Thank you so much, Ruben, for that question. It's quite insightful. I think that the one of our advantages which I highlighted the issue of being a member of the NEC. In the event an organization facing challenges, even under normal circumstances, maybe you are failing to operate as a business, you are facing challenges, you are not able to meet the wages, every employer is allowed to approach the NEC and apply what we may call the employee, they may come for the work for 1 week. They under any normal circumstances, even under normal circumstances, employers are allowed to apply for that waiver, whereby they can reduce in terms of the working hours, they can reduce in terms of the payments, to say this is what I can afford for now. I am facing these challenges in terms of operations, which means that respective NEC can grant you a waiver, while you are assessing whether the lockdown will be uplifted or it will continue. And once it's continued, we also approach the respective NEC in terms of the challenge you are facing. They will also respond to you and give you a guideline in terms of that. But what normally happens when in the event we say you are no longer able to continue operating, you want to cease operation, if you approach that respective entity, they will give you guideline in terms of say these are what you are supposed to pay to your employees. If you are now want to say you now want to wind up the operation of the business, you cannot continue. You are failing to continue operating. so that the respective NEC, they will give you the guidelines. That's one of the advantages of being a member of a particular employment council. They will give you the guidelines. You can apply to them in terms of waivers. You can apply to them in terms of any challenges you are facing. That's the purpose of having the National Employment Council for each particular, both they understand the operation, the dynamics of each and every industry. So they are able to guide you based on the dynamics of that particular industry. But when you are not part of the in particular NEC, it becomes a challenge now. Whom are you supposed to approach? Which means you now have to approach the Minister of Labor, which may be a higher authority in terms of termination, which may refer you to say, if this is a retrenchment, then you have to do the retrenchment procedures, and which may be very here for the employer in the long run. That's the challenges. But my advice would say, being a member of the NEC, you are able to apply, whereby you want to apply short time, maybe you are able to operate for 4 hours, you can apply for that, and you pay also remuneration to based on that upon their approval. So it will give an advantage. So my recommendation mainly is for even you are a startup, be a member of the NEC. There are minimum fees for small organization to pay. They even consider those issues so that you pay nominal fee. It's once in a year you should pay, and also the levy should be paying maybe 1% for the employee's wage on a particular month, which is quite fair from my perspective, which will help you in terms of you face such challenges you are discussing now.
Okay, thank you very much. Just a heads up, you have 9 minutes to go, and then we just need to take 2 to 3 minutes to close the session.
Thank you so much. I'll just run through this so that I think this will coming part of the end of my presentation. Then employee, the procedure should be fair for the employee, which means following the requirements in terms of your code of conduct or the national code of conduct. Then also the employee should be notified about the offense they've committed. You have to clarify what is the offense the employee has committed, and negligence. You have to be specific in terms of whatever you are quoting. Then you have to certify that the misconduct requires disciplinary proceeding. There are some misconduct which may not require disciplinary proceeding. You don't have to focus on that. You may caution the employee because it may not require to waste a lot of time doing all those disciplinary processes. Then also you have to know your code of conduct for that particular industry you are operating in. Or if you don't have a particular industry, you have to know the national code of conduct, the SI 15 of 2006. You have to know it so that when you're applying it, you apply it in the correct requirement procedures. Then you have to raise your proper charges. The charges should be correct and clear to the employee, and also give adequate notice for the hearing process. And the hearing should be convened and being chaired by an code of conduct. Now is very critical. So when you are doing a code of conduct, then it becomes tricky. You have to apply the national code of conduct in terms of that. Then you have also the law requires under Section 12B to consider mitigatory factors from the employee. What are the employee which has caused the employee to behave the way they violate in terms of the law? Mitigatory factors, they have to be considered, which means every employee have to consider in terms of that. Then you have to give a determination in writing to the employee to say, based on the hearing being conducted, so and so, you have been found guilty of the charges we have been charged with, or therefore you are either dismissed or you are on final warning. The employee has to be notified in terms of that. Then the employee sign the letter, so that when you have followed all the procedures in terms of your hearing process. So I think that's come to the end of my presentation. So my highlights may be in summary to say, as startups, I know we experience challenges in terms of operations. To give you my insights, when I was trying to register in South Africa, it took me almost close to 6 years. We started registering way back in 2003. We managed to do all the procedures, I think after a period of 5 years, to navigate all the challenges so that we comply in terms of legislation. So even when you're starting up, I'll make sure every time my tax clearance is in order, I submit my returns, even to NASA, if you submit your returns, so that you're always clear in terms of, I have few employees in terms of Zimbabwe, my employer are less than 5, but I have to make all those things have been done in terms of that. The other issue is maybe you don't want to avoid employment in large bulk of employees. You may also, depending on industry, there are students of attachment, they are apprentices. You give them an allowance so that they help you in terms of some of the work. In terms of administrative work, you may have one admin officer in the student attachment. They help you in terms of covering up some of the work. Then also, if you check in terms of last year, we've got the instrument. I have to check. It should be 79, which was considered last year, whereby even in terms of the minister's pronouncement, whereby you say if you are a startup in SME, you are employing the young people below the age of 30, they are reprieve or they are incentive given to those who employ employees who are below the should be age of 25, whereby there's a certain reprieve you are given from the ministry in terms of that. So which are the benefits as startup we have to explore? What are the benefits we enjoy as startup? As we're starting, we have to understand the environment we are operating in so that we navigate and we comply by all means in terms of the requirements. Once they've complied, we are keeping a clean sheet in terms of our employment relations. We are keeping a clean sheet in terms of our operations. We are having a clean sheet in terms of what we are doing. So which means we also reduced in terms of penalties we are avoiding. I'll give an example. Failure to pay as you earn is attracting a penalty of 100%, which means we are supposed to pay 10,000. You have to pay now 20,000, which will take it down in terms of your profits, which is not quite reasonable. And also try by all means to have a lean staff whereby it's manageable. It's also in line with your revenue. The best thing is to also do your budgeting. Once you've done your budgeting, how many employees do you need? You come up with the organogram. How many employees do you need for this startup to operate? Many they understand the clear vision of the organization, they will help the organization to grow. But if the employee they feel unfairly treated, there's no communication, there's no any discussion to give them the highlights what they're supposed to do. Mainly, they can also be business. So communication with our employees, highlighting to them, and also complying with all the legislation, it helps us in terms of delivery. It doesn't cost in terms of compliance. Compliance doesn't cost much, but it gives us a fair advantage in terms of our business operations. Thank you.
Thank you very much, Moreblessing. That's been quite comprehensive. At the same time, you've been able to navigate and stay within the time frames that we've been allocated. I just want to say, personally, I've also learned quite a lot. I also run my own startups or small business initiatives by the side. And definitely a lot of highlights came through and areas of opportunity that I need to explore. At this juncture, I'll just summarize what you have just said and the key learnings that have come through. You started off with the Constitution of Zimbabwe, and that the Constitution of Zimbabwe is trying to look out for the interests of the weaker party, and because the organizations or the companies already have got legislation that is pro-employer, the Companies Act and other acts, organizations like MCOS, CZI are pro-employer. So the MP is also taken care of by the Constitution of Zimbabwe. And the Constitution of Zimbabwe advocates for fair labor practices as well as the right to a fair wage or salary. That's the primary takeoff in terms of the Constitution of Zimbabwe. And then under below the Constitution of Zimbabwe comes in the Labor Act, which goes into detail about the relations between the employer and the employee, the rights of the employee to join a labor union a trade union of their choice, the right of the employee to join a workers' committee, the requirement also by the Labor Act that if you've got above 10 employees, as you've said, 10 or above employees, then you must have a a workers' committee at your site. Also, you must then allow the employees to subscribe to a trade union of their choice. This is mandatory. It's not by choice that you do this. Then there's also the issue to do with the NEC. It's encouraged that as an employer, you join an NEC that is to what you do, so that you gain being part of such an NEC. Primarily, you benefit from the information. If there are any developments, the government passes any statutory instruments, or there is a collective bargaining agreement that has come through, you stand to get the information first. Businesses are not aware of the implications. The organizations tend to default to casualization a lot, but yet at the end of the day, casualization actually exposes us to a lot of risks because we do not understand how casualization works, and in the process we could actually be raising a legitimate expectation with our staff, and by the time we decide to terminate them for one reason or the other, they may then approach the courts, and they actually will the courts might actually favor them because they are trying to look out for the interests of the weaker party. Then the discrimination, when you talked about where the organization are not supposed to discriminate across according to gender, color, creed, religion, political affiliation, and whatever basis of discrimination, these are deemed as unfair labor practices. And you went on to talk about job descriptions, and you talked about the importance of a job description. At first instance, the job description clarifies and helps the employee get a framework, a guideline for them to be able to operate efficiently and effectively. However, also it's important that these job descriptions are written so that you can then hold the staff accountable, and you can try and get the best performance out of them. Where you also then talked about a job description, for instance, in an organization where maybe there are 2-3 employees, and one employee is catering for procurement, receptionist duties, you can then maybe call them an administrator. And then you don't necessarily have to indicate the manual labor that they might from time to time be called upon to execute, because the organization is small. These are deemed as any other duties as deemed necessary by the organization. Then you spoke about the compensation, and you spoke about the thresholds that the NEC sets around compensation and why it is important for the organization to comply with this, inclusive of the taxation implications, and how the government or the ministry will penalize the organization if you flout any of these issues to do with compensation. This is in line with the constitution and anyway of Zimbabwe, which talks about fair salary or wage for every employee. Then harassment is certainly one of those issues that also was covered. And as organizations or as business leaders, we need to make sure that we stay clear of any issues that may be deemed as harassment. And I know in most organizations, one of the pitfalls is when a boss exerts themselves in an inappropriate manner towards their subordinates. Harassment is actually a very dangerous issue with business owners, and we need to safeguard against that. These are some of the issues that actually damage the reputation of any company. Then you, lastly but not least, spoke about the disciplinary and termination procedures, and you went quite into detail about the procedural fairness, substantive fairness, guidelines, and what documentation must be compiled so that this is achieved. Having said that, thank you very much, Moreblessing. I know quite a number of times I put you on the spot. The small businesses or the startups are not a normal a dish of salsa that you have every day. They are more established organizations that you work with, which have got formalized systems and are very easy to deal with. But the companies that our mentees are trying to run are those that are struggling a lot with trying to get on their feet, try to manage costs, and try to become efficient and deliver on customer expectations. And you did very well, and you were quite elaborative in your responses to the key questions and key challenges that face small organizations. Thank you very much. Thank you to Simuka Human Capital for hosting this Green Enterprise Initiative under the International Labour Organization banner. My name is Ruben Lambo. We're signing off. Thank you.
Thank you so much, Ruben. Thank you so much, the Simuka brand. Thank you.